Earlier today, we told you that Gina Carano is facing not only Disney, but Disney has hired the former attorney for Weinstein, alongside, I guess, Leslie Headland, who is the former personal assistant to Weinstein, running a Star Wars show. The question now is, does Gina Carano have a foot to stand upon? Will she succeed in a motion to dismiss her lawsuit placed down by Bob Iger and the Disney company? It's time for legal analysis like you'll find nowhere else, folks. Here we go. Hello, ladies and gentlemen. Welcome back to the Pro Channel. We are so happy to have you here with us, where we endeavor to explain entertainment and keep you ahead of the culture curve. Joining us to keep us ahead of the legal curve is attorney for that Park Place, Ron Coleman. Welcome back, sir.
My pleasure. Thanks for having me. How you doing?
Doing wonderful, Ron, and I cannot wait for your expert analysis. I am always extremely appreciative when you can come on the show. Of course, you have a tremendous following all across social media. And folks, I'm telling you, I have seen Ron's posts on YouTube Shorts and YouTube videos appearing everywhere all of a sudden. It is obvious that so many of you out there have discovered what a genius Ron is, and you want to know what he is putting out there for you to know. So here we go with just that sort of thing. Ron, this is the finale of the motion to dismiss from Disney. We're going to go to the finale because I think that in large part, this is where the meat of the matter is. And so this is Disney claiming that they have a First Amendment right to get rid of Gina Carano, and she doesn't have a First Amendment right to express her opinions and stay on board with them. It's also interesting because they're going to, in some people think what they're doing here is they are affirming that they hold a political viewpoint that is counter to Gina and so many who think like her. And this again gets them into that same situation from when they were in Florida, when suddenly having a political viewpoint got them in all kinds of trouble. Here's the statement. It says, Disney's First Amendment right to disassociate its speech from Carano's offensive viewpoints precludes all three of Carano's causes of action. Counts 1 and 2 of Carano's complaint are plainly barred by the First Amendment. In those counts, Carano seeks to hold Disney liable for taking into adverse action against her based on Disney's disagreement with Carano's political beliefs. So there that is, folks. There's them saying we disagree with Carano. And frankly, I think Carano is rather moderate. But as already explained, Disney had a constitutional right to disassociate its own artistic message from Carano's outspoken political beliefs. Because these claims aim to require Disney to modify the content of its expression, they cannot proceed. The analysis for count 3 is no different. That claim asserts a sex discrimination claim on the theory that Carano was terminated because of her social media posts expressing her personal political beliefs, while her male co-workers who did the same were not terminated. But Carano expressly acknowledges that the male co-workers' statements differed from her own. Indeed, the complaint on its face reveals a litany of differences between Carano's statements and those of other actors. Now, heads up, folks, what that's talking about is Mark Hamill and Pedro Pascal hold very different political viewpoints than Gina Carano. However, Carl Weathers seems to have held beliefs that were extremely similar to Gina Carano. He was not fired, she was, or at least she was not renewed, and very publicly shamed in that process. Indeed, the complaint on its face reveals a litany of differences between those other actors. As explained above, the First Amendment protects Disney's decision to disassociate itself from some speech, but not from another different speech. Carano evidently believes the other actors' statements were sufficiently similar to hers to warrant identical concern from Disney, but under the rule of speaker's autonomy, that determination is not for her or a jury to make. Rather, the First Amendment mandates deference to the speaker's own decisions about what speech to associate with, even if others might consider those decisions internally inconsistent. And so that's the defense. There's also a very strange thing, Ron, where Disney is likewise claiming that because Gina responded to various accounts in a pre-Elon Musk Twitter world, that's different than Mark Hamill. That's different than Pedro Pascal and so many others. I don't know how that's qualitatively different, but that's what they are claiming. Ron, give us your take on the likelihood of this surviving and going past this stage.
We have an expression that you learn in law school, which is that hard cases make bad law. And this may very well be an example of a hard case that's going to make some rather hairy law, or a hard case that's going to make some bad law. As a general rule, everything Disney has said is true. On its face, it's true. We have seen many times people on Twitter calling the attention of employers to the online or offline offensive conduct of their employees, and those people getting canned. Now, as a general rule, you can fire someone for any reason or no reason at all, subject to the terms of a written contract or collective bargaining or unlawful discrimination based on sex, creed, national origin, race, of course. Here's where it gets difficult. California has a unique law. There's nothing quite like it anywhere else. New York has a similar law, but not nearly as sharp. It's the first claim for relief in the complaint. It's California Labor Code 1101. And although our firm is headquartered in San Francisco, I'm speaking to you from Newark, New Jersey. I'm not admitted to practice in California. I practice in New York and New Jersey. Obviously, I'm involved in some California cases as a visiting attorney. But under this California law, an employer is prohibited from making, adapting, or enforcing any rule, regulation, or policy that forbids or prevents an employee from engaging or participating in politics or from becoming candidates for public office, or controlling, directing, or tending to control or direct the political activities or affiliations of employees. My recollection is that the purpose of this law, the Unruh Act, was to protect commies.
When was this enacted, Ron? When did this come through the legislature?
I think in the 60s.
Gotcha.
But I wouldn't want to, I wish I would have had the answer for you, but have I mentioned I'm not a California attorney? But that's what I think it was. And the idea was that, of course, there was a blacklist. There was an extensive communist infiltration into the show business sector. It really did exist. A lot of those people were communists, and a lot of those people lost their jobs if they were revealed as being communists. And I think that later, after the communists and their friends took over the political system or had more influence, this legislation passed. So fundamentally, back in the day when speaking truth to power actually was something left-wingers did, this was meant to protect them, although the law by its terms is entirely facially neutral as to which side is involved. There has always been a constitutional question about this law because it does interfere with the at-will employment, which is a contractual issue that's protected under the Constitution. And it arguably interferes with the First Amendment right of association belonging to the employer. So one of the threshold questions here, which may not be amenable to a decision at this stage, at the motion to dismiss stage, is it reasonable for Disney to assert that as a matter of law, an actress that it employs, either under a contract as a 1099 contractor or as a W-2 employer, I don't know which it is, I'm sure it's in the complaint, I'm not sure it matters that much, is truly someone that the public associates with Disney? Does anyone think that the things that Gina Carano says are things that Disney itself is associating itself with? Because as you pointed out, what Disney is saying is, these people we didn't fire, we do choose to associate ourselves with those comments.
Right, and some of those comments, by the way, are very abhorrent and atrocious, even, I would say. So that's interesting.
It's more than interesting. It at the very least, I would be in responding to this motion, making Disney pay for these, comparative comments, the car weather, not only the car weather stuff. And as you point out, whenever you allege discrimination, one of the responses is always going to be, well, no, someone else, we also fired someone else. Or we didn't fire, or you say you didn't fire someone else, but you fired me. They say, well, that was different. So then it always comes down to, well, is it a difference? Is it a distinction with a difference, or is there really a material difference? Disney's saying, yeah, there is a material difference. What's the material difference? We agree with these things. And that in and of itself in 49 states would be enough.
Right.
But in California, and maybe not in New York, there is also a similar law in New York. But in California, it isn't enough. There's unless the court is going to rule that the Unruh Act is unconstitutional, or at least unconstitutional as applied here. It would appear that this raises a legitimate question that might not be able to be resolved on a motion to dismiss. And then there are, of course, the follow-on effects of whether Disney really does adopt the positions of those other people that it has called upon. And I do think that the sex harassment claim, in a way, it has certain strengths to it, but in another way, it just doesn't intuitively ring true.
Right.
I don't know really enough about the business to tell you why Carl Weathers would be tolerated and not Gina Carano, except that I think Carl Weathers was a bigger star than Gina Carano.
Sure. So, Ron, let me ask you this. We all know that we would love to live in a world where there are no pressures outside of a court system that influence in any way, but we live in the real world.
I want to point out again, I mean, if I find out that one of the biggest activities among Jewish people who are actively Jewish in social media over the last few months has been identifying people who vociferously express their support for atrocities committed by
right,
and bringing them to the attention of their employers and trying to get them canned. And there's nothing wrong with that. And it's something that the left has done. They utterly destroyed the reputation of people who are basically acting as overgrown Boy Scouts in the people's lives have been ruined by this, and the law has generally supported people's rights to do this. But California law here is what makes it interesting.
So this is where I'm going with that, and you tell me if I'm wrong. My thought on this is that this Gina Carano case is actually much bigger than it might first appear. Of course, legally backed, financially backed by Elon Musk, so that elevates it. But it seems to me that there could be a cascade event. This could actually affect far more than Gina Carano. If she's successful here, if this survives, the longer it survives even, it opens the door to conservative actors, even moderate actors and participants in Hollywood saying, now, wait a minute. If she's going to get justice in this area, I'm going to get justice too. And so I wondered if the industry might be looking at this and saying, whoa, we gotta stop this. And if that might create some pressures external.
It might. And let me also, before we move away from the statute, let's remember what I read. That an employer is prohibited from taking adverse action, let's call it, against an employee in connection with that employee's engagement or participation in politics, political activities, running for political office, and the last phrase is affiliations of employees, meaning if you're a member of the Communist Party. I'm not sure. I didn't read the motion, and I don't know whether they go there. I'm not sure that posting your political opinions is, strictly speaking, and this is a statute that arguably is going to be read strictly, Maybe not. And I'll tell you in a second why not. But on the one hand, you have the constitutional issues that militate against giving a broad interpretation to the statute. And on, I don't know whether I said on the other hand, on the one hand, and on the other hand, this may be deemed what's called a remedial statute. A remedial statute means where a legislature sees a problem, not merely a regulatory goal, but it sees a problem and goes out to solve it. If this were to be construed as a remedial statute, then it might be read more broadly. And again, people with experience in litigating these issues in California could speak more intelligently to that. But depending on how it's read, it is possible for a judge to avoid this problem altogether by saying these aren't political activities. These are statements of opinions. Yes, we live in a politicized times, and yes, everything's political. But you weren't running for office. You weren't raising funds for a political candidate. Ironically, under that reasoning, if she were raising funds for Donald Trump, or perhaps for even some real far-right figure, which Donald Trump isn't, that would arguably be more protectable than merely making mean tweets.
If she had been more of a political activist, she'd be more defended than this from just being, rather than just being someone casually voicing their opinion.
So then the question is, did the legislature intend to capture that less, to give more protection to someone who does less, or less protection to someone who does less? And that's a really interesting question. I'm sure there have been law review articles written on this. And again, but again, what, as you pointed out, Pro, what the court decides here does inevitably have follow-on effects in other cases. And if the judge were to say that it's got to be political, it can't be merely an expression of opinion on a controversial topic, will we then see people appending, that's why I say vote for Trump, or that's why and even to the extent where people will say, that's why I say, vote for the German-American Bund. There, now it's political. Does that make it better? It doesn't make it better for the employer, it makes it worse for the employer, but now the employee is more protected than he would have been otherwise.
Unintended consequences of that law. But let's take a look at this article out of That Park Place. Legal analyst reacts to the Walt Disney Company's motion to dismiss Gina Carano's lawsuit. Will be another huge fail for Disney. It's talking about legal mindset. Andrew Esquire, of course, over there at that article or that channel. But I want to read this to you, Ron, and see what you think about it. It says, Esquire stated, so they filed a motion to dismiss, which really doesn't address the merits of the claim or really prove that it is a meritless claim. Remember, a motion to dismiss is supposed to prove that they lack merits completely, that there's zero merit, zero substance to the case, to the Gina Carano case. And what we see here is, in fact, that, well, that's not addressing whether or not these claims of preference are actually merited one way or another. It also doesn't address any of the labor laws, because these are brought under very specific labor laws, which have absolutely nothing to do with what Disney is claiming. This isn't about punishing Disney's speech, right? So Disney, once again, using the First Amendment defense is very weird, because it's not about them. It's about the firing of an employee and firing of an employee for their political views, which, of course, in California is illegal. Andrew goes on to say that he essentially thinks that this is another poor performance by Disney. And by the way, Ron, same attorneys that represented Disney in Florida, where they just lost badly with a settlement that essentially means they'll be paying about $1 trillion over the next century in terms of all of those taxes and impact fees and levies and all of that they...
You make that sound like a bad thing.
I know. Bob says it's great. Ron, any disagreements with what Andrew's saying here? If you were Disney, how would you have responded?
I would respond the same way. But there's not. This is the response to make. I think, and to some extent, Andrew is saying what Andrew is saying aligns with what I'm saying. If you accept the premise that I don't think he's asking the question I am, is this really political speech? And will the statute be interpreted broadly versus narrowly? But an important threshold question, which may or may not be a legal one. In other words, it may be one that requires factual development to answer, in which case Disney loses the motion. Is it, if Disney is hanging its hat on its First Amendment association rights, which tends to be, which is becoming a very, very popular, in other words, all the social media companies that have defended their rights to act as editors and publishers rather than neutral platforms have always said, on the one hand, we have Section 230 protection, we're a neutral platform. And on the other hand, they say, we have a free speech right not to be associated with the speech of this person that we banned. And courts have actually been rightfully skeptical, even though they still make that argument, of the idea that anyone really associates Twitter or Facebook, et cetera, with the user of that service. You could go another step and say, well, you see, this is what Twitter tolerates, and therefore they're not saying it, but this is what that's how. Well, that's interesting, but that's not. I don't believe that's what the First Amendment right of association covers. And I think Disney has a hard burden to overcome here by arguing. It would be different if they were suing Jiminy Cricket, or if they were suing someone who is really, some actor who is really, really closely tied with the Disney business for decades.
Sure.
But Gina Carano, yes, people in your space and who follow this stuff, this is a big sprawling company. It's pretty attenuated, and you might require a survey to demonstrate that the public associates the views of the various actors with the company. But again, if Disney says that, then they really are moving into a world where every tweet by everyone they don't fire for his tweets is endorsed by them. Boy, that's a crazy world to live in. And in fact, as a matter of policy, it seems like a pretty bad one, because it's gonna bite them in the behind, because there's going to be another case later where that view is going to, or someone's going to try to ascribe that view to Disney. Let me just make another point. You mentioned that this is the same law firm as the law firm that represented Disney, and they lost. This is one of the best law firms in the world. That's why Disney hired them. You can be sure that they're doing what the best practice approach is, that they're taking what is the best practice approach in every one of these cases. So I would, in a million years, not mock the ability or the judgment of the lawyers. They have to do what their clients ask them to do. And in the case of these law firms, you can be certain that they're doing it in the best possible way. But it does implicate a number of definite strategic decisions that have wider implications than this case. And on the other hand, it's hard to imagine if you're Disney management, regardless of what the decision or what the subject matter itself is, it's hard to imagine any scenario where you as an employer would want to accept the position, whether in California or otherwise, that you can't fire someone who works for you, who says something that you consider to be outrageous and disgusting.
Fair. Ron, you tell me if this is the right assessment, and then we'll wrap up. But seems to me right now, I think that it's more likely than not that this will survive past a motion to dismiss. It also seems to me that this is a very difficult case for Gina Carano to win. And third thing, it also seems to me that if it makes it to discovery, that is not in Disney's best interest whatsoever. Are all three of those correct?
All three of those are correct, but I'm not as confident as Andrew in the outcome of the motion, because not necessarily because his legal argument is wrong or right, but because the judges in California, especially when it comes to show business and the people's commissariat of entertainment and right think, tend to be very, how shall I put it, bad.
Well, one good thing for you, Ron, is it appears the police have not yet found your location. They continue to circle around, but never find you.
They'll never guess where I am.
All right, folks, if you are looking for legal analysis at a level that you absolutely need to be indulging in every single day, check out Ron Coleman, not only on X, but also on YouTube. Links are in the description down below. We highly recommend. Also, like, share, subscribe, click it, stick it to the algorithms, it's the notification bell, and drop a comment down below. Folks, the Pro Show is live if you're watching this video at the time of release in just a few hours, 5 p.m. Eastern Time, a special edition of the Pro Show. Be there. Folks, wherever you are and whatever you're doing, keep learning, keep growing, and keep having fun.
All right, Bob, we need to make sure we got all your legal strategies figured out.
Well, Mr. Lawyer, I'm thinking this is probably a good idea considering everything we've been up to at the company.
First, we need to make sure that you understand that anything and everything you say will likely be used against you. So, you should always wear your heart on your sleeve and say out loud what that inside voice is saying.
Are you sure? That kind of goes against what I know.
Yep. You can then play the ignorance card. Then no one will think you're super manipulative or malicious.
Brilliant. One of the big things I need advice for is our whole Reedy Creek situation.
What's the problem there?
Well, you see, at the company, we take pride
Let me stop you right there. Stop the spin. Just admit what you're doing in front of your investors.
That doesn't sound very smart.
Who's the lawyer here, Bob?